conditions. And I don't want to give you a false sense of complacency, like, oh man, I got an A on the midterm, I can sail, right? I want you to understand this is how the final grade will be assigned. Okay. Third, the curve here was lower than the final exam, which is expected. Usually my curve is around a 312, 311, give or take. This is a 2.9. Okay. So what does that mean? You got some room to improve. So whatever grade you got, more likely than not, you'll do better in the final. Okay? Because I graded you very tough in the midterm, more likely than not, you will do better in the final merely because you have another half semester under your belt. You have the experience of taking this midterm. Okay? Now, for some of you, if you got a C- or lower, I want you to come see. I'm not going to yell at you. I'm not going to chew you out. I want to help. The reason why I want to help is because we can correct stuff, right? Maybe you didn't do something right. Maybe you weren't studying right. I don't know. But this midterm is a good way of, raising a flag halfway through, saying, hey, wait a minute, I maybe don't get this stuff as well as I should get it. Understand? Okay, so I put some comments here. Also, I put the exam you can download and also the A+ paper you can also download. I strongly encourage you to do this while the exam is still fresh in your mind. I hustled. I did nothing this weekend but grade papers. I did every paper for both common law and property in one weekend. This is my entire weekend, so you're welcome. But I did this because I want it to be fresh in your minds. And I want it to be, you can actually look at the exams. Oh, yeah, the thing about Simba, right? Yes, it'll be fresh. If I did this in 6 weeks, you won't remember anything. So do yourself a favor. Go take 20 minutes. Go review the exam. Go review the A+ answer. If you still have some questions, email me. We can schedule a time to meet. But if you got below C- or lower, that's not optional. That's a mandatory. Come see me. There weren't that many, but if you're in that range, I want to help you. Okay. Stupid note: if you come talk to me, make sure you Make sure you scratch out your exam number on your paper because I can't see what your exam number is. It's absurd, but I want to try and do things the right way, and I don't want to inadvertently betray the blind grading scheme because I'd feel quite terrible about that. Okay? And also, I have a couple high-level issues in terms of the adverse possession. Almost all of you got the first question, but some of you missed the disability. There was a tolling. I'm sorry, there was a disability because Simba was a minor. A bunch of you missed that. There was a second question about I will give you this land after I die. Okay? That's called a testamentary gift. That's not inter vivos, and you need to comply with the statute of wills. You can't give a gift that takes effect after death because there's no delivery present. We did a case like that as well. Deed to the son saying you can have this after I die. That doesn't fly. There were a couple of questions about disclosure of defects and as well as marketability of titles. About latent defects, and I even had a haunted. I'm trying to figure how the hell do I work in a haunted house case. So the haunted sky from The Lion King. I take joy writing these exams. I really do enjoy them. Trying to actually fit the plot of the movie. It's more difficult than you think. And the last one, with if you indulge my grotesqueness on the flatulence, it was a nuisance question and whether you actually understood the difference between injunction and damages, which was, I was trying to get you to explore the correct remedy for the nuisance. Yeah, read through that. Again, if you have questions, you're welcome to email me, but I want this to be a helpful experience for everyone in the class to make sure that you guys are on the right track. We have a curve in this school, so not everyone can get an A. It's simply impossible. But I want the average grade to be as high as possible because the average grade is a 310, which we're actually you may not even know this, but the school gives us a forced curve. Okay, we are required to give a class average between 285 and 315. That's I don't have an option. If I want to go above or below that, I have to talk to the dean, and that doesn't work. So I tried to get my class as high as I can. Usually it's around 311, 312, give or take. So even if I can't get from an A, the rising tide lifts all boats. If you do well, everyone will have a high mean, and there will be fewer people who are unhappy with their grades. One final note, and this is not just for me, but this is for everyone. If you ever go to a professor to talk about what you do not do. I read the A+ paper. I wrote the same thing. I should have gotten more points. Never, ever, ever do that, okay? For a couple reasons. First, we don't have any discretion to change grades. Believe it or not, if I want to actually change your grades, I need to write a letter to a committee, and they have to approve it. I once had this mistake, the only time I ever changed a grade, where I had a spreadsheet supposed to add up 2 columns for question A and question 1 and question 2. For whatever reason, the formula didn't work, and it did only 1 column. So instead of having like an 80, the kid got a 40, right? Kid walked in like a C minus. He was really upset. I was like, well, let me take a look at your paper. I was like, that's not where you should have had an A. And then I changed it. Arithmetic mistakes are one of the few exceptions. We do not have discretionary mistakes. Like, oh, you know what? Yeah, I guess you really hit that question right. We can't change it. But also, perhaps more pressingly, when you start doing that, it looks very petty. And also, you're not really discussing how to improve your work. You're trying to attack the professor's grading. Don't do it. This happens every year. At least 3 or 4 people come by. It's an awkward conversation. It lasts all of 30 seconds, and people usually storm off and they're all upset. Just save yourself the trouble. If you get a bad grade, learn from it. I got a couple bad grades in law school. I got a C+ in torts my first semester. You don't forget those, right? But you can recover, and you shall overcome, I suppose. Okay. Any other big questions on the midterm? Or, I mean, if you have questions about the content, come talk to me. But any other just big questions? Okay, good. Yeah, and again, I think for the most part, you guys did okay. I mean, I was, I didn't know quite what to expect halfway through the semester, but you did okay. I mean, you're not where you ought to be at the end of the semester, but you're where you should be now, more or less, give or take. I think you're learning property, which is also an edification. I'm not sitting up here and wasting my time. So, congratulations. Okay. All right. Any questions on covenants? I realize our last class was a fairly, not an intuitive class. It was not intuitive, and I want to make sure you understand that diagram with the 4 letters. Did everyone get a chance to sign this? Wow, that's quick, guys. Good job. So I understand everyone. I want you to get that 4-point diagram. You should be able to draw that like in your sleep by the time the exam comes. You should be able to look at a fact pattern and say, okay, because I'm not going to give you a fact pattern A, B, C, D. It's going to be a little more complicated. You say, okay, here's the original grantor, here's the grantee, there's the covenant, horizontal privity. Okay, here's the burden running, here's the benefit running. You're going to need to, on the fly, do this. Now, I have a lot of old exams from years past. If you want to practice this, just go click on my old exam and do a search for the word covenant, and the question will come up with covenant. There's only like 8 or 9 of them, and see how I asked it before. Because I'm not that creative, right? If I asked a question like this a couple years ago, odds are it will be, in the ballpark how I'll ask it this year. I can only ask you so many different ways if a burden runs. It's not that original. That's why, I don't talk much about the bar, but there are only so many ways that bar examiners can test you on the same question, right? There are only so many ways. If you do enough old questions, you'll be able to answer the new questions. It's not rocket science if I had to test property. Okay. Any questions on covenants, burdens? The burden certainly runs in. Chill out, relax. It's okay, you can laugh. Anything in your minds? Okay. So today's class will actually be, we'll start off a little bit differently because we're actually doing a Supreme Court case, which does not happen very often. And the significance of this case is a practical reality of property law. And you're not my con law students, but I can give you a little bit of a history here. After the Civil War, the Reconstruction Amendments were ratified. Of course, you have the 13th Amendment, which eliminated slavery. You have the 14th Amendment, which provided protections of equal protection and due process of law. And you have the 15th Amendment, which provided the franchise regardless of your skin color. Okay? But that didn't make everything immediately awesome, and it took quite a while. So in the aftermath of the 14th Amendment and in the ending days of Reconstruction, many states, not only in the South, but predominantly in the South, enacted laws that were known as Jim Crow. Okay, and the purpose of Jim Crow was to erect a state of segregation. Now, it wasn't actually the sort of segregation that existed before the Civil War. There wasn't slavery and those sorts of things, but it tried to get as close as possible to that state as humanly possible. So you'll study a case in common law if you haven't already, called Plessy versus Ferguson. You guys heard this yet? Okay, I taught it yesterday, so you guys right in the right target. Where the state of Louisiana passed a law mandating that train cars be segregated, and the Supreme Court, in a decision that is, not looked on too favorably today, said, well, that's fine, because as long as the accommodations are separate, as long as the accommodations are equal, you can separate the races. Okay. There were also cases, for example, the civil rights cases, right? So the civil rights cases were like this. Congress passed a law called the Civil Rights Act of 1875, which said that various places of public accommodation could not segregate. So, for example, a hotel, a restaurant, an opera house, right? Places of public accommodation. The Supreme Court held that that law was unconstitutional. Okay, so you remember why the Civil Rights Act of 1875 was unconstitutional? No, not commerce. Close. No, anyone remember? Section 5 of the 14th Amendment? Oh, you break my heart. Okay, so I have here, of course, no snarky comments. I have here, of course, the 14th Amendment, which you should all know by heart. Yeah. No, you're thinking of Dred Scott, but you're way off. The civil rights cases, right, involved whether Congress had the power to force private businesses to desegregate. Okay? This was it 1880 something. Do you want to take a guess why the Supreme Court said that, and this is relevant to our case, not just spinning off. Does anyone want to take a guess why the 14th Amendment, why Congress could not regulate private businesses if they sought to have segregated accommodations?
Because private businesses are not engaged in state action.
Yes, perfect. State action, right? Remember the state action doctrine? Now it comes back, right? The 14th Amendment applies by its very terms to the states, right? It says no state shall deny to any person the equal protection of the laws. No state shall deny to any person equal protection of the laws. Okay? Is a restaurant a state? Is a state? Is a opera house a state? The answer is no. And the Supreme Court held that when you have private businesses engaging in conduct, the Constitution cannot reach it, right? The 14th Amendment only touches state action, okay? In contrast, if I may, with the 13th Amendment. The 13th Amendment eliminated slavery. But it didn't just eliminate slaves owned by the government, it eliminated slaves owned by everyone. In fact, the 13th Amendment says neither slavery nor involuntary servitude shall exist in the United States. Shall exist means nowhere. Government can't own slaves. Private businesses can't own slaves. People cannot own slaves. So the court drew a distinction between the 13th Amendment, which regulates private conduct, and the 14th Amendment, which regulates state action. Okay, everyone see the difference, right? Why is this relevant? Why is Blackman wasting our time at common law? We learned with trees, right? Why am I wasting your time? The reason why is because when you don't have the 14th Amendment controlling private people are free to discriminate. Okay? When the 14th Amendment does not control what private businesses do, unless Congress passes some other sort of law, which didn't happen until 1968 or 1965, depending on your count, you cannot get rid of discrimination. So during Jim Crow, one method that was used, very popular method that was used to enforce segregation was the covenant, right? Was the covenant. I thought I was going to connect it, right? You didn't need the city. You didn't need the city to pass a law saying that, okay, the whites live in this neighborhood and blacks can live in that neighborhood. You didn't need that. Because if property owners are able to restrict the ownership of their land based on a covenant that runs with the land that burdens subsequent owners, you can accomplish segregation. And I'll give you one more to make this point more fine. Has anyone ever heard of a case called Buchanan versus Warley? 1918, give or take. Okay, so what happened? The city of Louisville, Kentucky, where I lived before coming down to Houston, passed a law. And what did this law say? Law said like this: this neighborhood over here, this is the white neighborhood. And that neighborhood over there, that's the black neighborhood. If you are a white person, you can't buy a house in the black neighborhood. And if you are a black person, you can't buy a house in the white neighborhood. Now, of course, the white people weren't trying to, barge down and buy all the houses in the black neighborhood. This was obviously a method to keep black families out of the white neighborhoods. But under Plessy versus Ferguson, prevailing doctrine, there were separate neighborhoods, right? They were equal. But there was a different way of challenging this segregation, right? So the 14th Amendment also says, no person shall deprive a state of life, liberty, or property without due process of law. Life, liberty, or property? Wait a minute. Do I have a liberty interest, a right to sell and buy property? Well, yeah. So before the 14th Amendment was ratified, there was a law called the Civil Rights Act of 1866. Did you study this? The Civil Rights Act of 1866, which was vetoed by President Johnson, purported to give the freedmen, right, the freed slaves, a whole host of constitutional rights. Not a whole host of civil rights, let me say it like that, right? One of these rights is very important for our class, the right to buy and sell property, right? The bundle of sticks, so to speak. The Reconstruction Congress recognized unless the freedmen were able to buy and sell land, they could not be people. They could not be citizens in our polity, right? If you can't own your land and you can't sell your land, what are you going to do for a living? Oh, you have to live on someone else's land, called sharecropping, right? There was a very strong sense, the ratification of the 14th Amendment, that one of these sorts of liberty interests was, in fact, the alienation of property. Now, have you guys say Lochner yet? Okay, you'll study a case called Lochner, and your professor will probably tell you it's the most evil case in the world, right? The Lochner decision involved the facts were like this. The state of New York passed a law saying that bakers could not work more than a certain number of hours per week. Great, you say that's a wonderful law. Well, the bakers didn't agree with it because they wanted to work more hours because they were poor immigrants who couldn't afford it. They actually wanted to work more than whatever 60 hours a week. And the Supreme Court, in a very controversial 5-4 decision, invalidated the law, saying that this is a violation of what's called the liberty of contract. If someone wants to work that many hours per week, they can. Okay. This case was ridiculed, saying that how dare the state get involved with the private contracts of people, right? If the state wants to regulate working conditions and these sorts of private conditions, they can do that, right? Who cares? People's liberty interests. Fine. You'll learn about Lochner later. But one of the extensions of the Lochner doctrine came back in Louisville, in Buchanan versus Warley. And the facts were like this. If I am a white property owner and I want to sell my house to a black family, how can the state get involved with that contract? How can the state interfere with my liberty of contract if I want to sell this home? How can the state deprive me of this liberty interest that any due process of law? So you can't sell this house whoever you want. It's my right, my bundle of sticks. I can alienate whomever I choose. And what did the Supreme Court hold in Buchanan v. Warley? He was right. Even while Plessy was still controlling law, the Supreme Court invalidated the Louisville law and said that the state cannot tell you who you can and cannot sell your property to. Right? The state cannot pass a law restricting your alienation of property. That is your liberty interest. So when you study Lochner, I'm sure your professor will say it was the most evil decision ever. Just ask about Buchanan versus Warley. And, well, I'm trolling a bit, but you'll see what happened. Okay, great. So what does that happen? What happens after Buchanan, right? Cities can no longer impose segregation by law. But what happens if it's not the city imposing the segregation? What happens if it's private parties imposing the segregation? Through the law of covenants. And that is the background for the case we have today. The reason why racially restrictive covenants became so popular is the Supreme Court said, even under Plessy, you can't segregate neighborhoods. You can't restrict the liberty of contract to sell product when you choose. So instead, neighborhoods start signing these racially restrictive covenants where everyone, or virtually everyone on the block, agreed to bind their properties to impose a burden on subsequent owners such that they could not sell the land to a black family. Okay? Everyone get that history. The history is very important. And one other note, in this case, Shelley v. Kraemer, only 6 justices participated. Anyone want to take a guess why 3 justices recused? Want to take a guess? Why did only 6 justices participate in Shelley v. Kraemer, 1948 Supreme Court decision? Want to take a guess? I'm sorry? Close. Want to take another guess? Their houses had restrictive covenants on them. In 1948, in the District of Columbia, I'm not talking about Mississippi, right? No offense, Mississippi. But in 1948, in the District of Columbia, 3 of the justices who probably lived in well-to-do neighborhoods in Maryland or Virginia or DC had these sorts of covenants on their houses. I promise you, if you guys did a title search for your home in Texas and went back 60, 70 years, you'll find them. I have no doubt in my mind. These were extremely, extremely common. And you'll find these recorded on your deeds. I'm willing to bet money. You know about this?
Yeah. I looked at the deed for the house I lived in a few years. It had it in there.
Do you know what year it was from?
The covenant?
Yes.
I don't recall off the top of my head. I know it had been amended to no longer apply, but it's still in the deed.
It's still in there,
and,
yeah.
And that applies to all of Tanglewood and I believe to River Oaks as well.
Really?
It's still in the deed. It's been amended.
She said Tanglewood and River Oaks. Okay, that's news to me. I didn't know that.
Oh, I know Tanglewood, but we might have seen it.
All right, so before we get into the sort of constitutional issues, which are important, let's try and see as smart property students, right? How could you have attacked this under property law? It's like the opposite way you usually do, right? How could you have taken down, or what aspect of these racially restrictive covenants do you think were vulnerable to attack under property law? And think of what we discussed last week about, or last week, on Monday, about covenants. You want to take a stab? There's a couple things I can think of that may have inhibited the enforcement of these covenants. Want to take a stab? Cameron?
States are enforcing.
No, I'm not getting it yet. Between private people, right? I heard someone say it. Who said it? What do you mean privity? Explain more. Oh, so good. So remember we discussed with the Neponza case, right? Remember we discussed with the Neponza case. We talked about these homeowners associations. And what were the deals with these homeowner associations, right? These weren't these weren't agreements between, party A and party B. These were agreements where basically everyone in the community came together in this sort of artificial form to bind everyone. And you're exactly right. Under the common law, these sorts of restrictive covenants were not valid. Think of the facts of this case, right? All these people on the block came together and they signed these covenants together, right? Was there any horizontal privity? Did everyone start selling, okay, we're going to take this land, subdivide, and put the covenant in each house? No, they didn't. They said, all right, let's come together, shake hands, and write these covenants. So under the common law, are any of these covenants valid? No. With the absence of horizontal privity, burdens cannot run. And you're exactly right. This entire idea of having a community organization, that is a fairly novel idea in property. So again, under the common law, these would not have been valid. And I want to take another stab. There's one other one a little bit tougher to think of, but it's there. Yeah, right?
Could you have possibly gotten the sellers for fraud or misrepresentation?
Well, here, this is actually a fair point, right? In the case we have here, Shelley v. Kraemer, the deed in question didn't have the restrictive covenant on it, right? So I'm going to ask you a question, and this is going to be blunt. Is there constructive notice? If you're a black family buying a house, and you realize everyone in the block is white, should you be on constructive notice that there's a restrictive covenant on the property? This is not an insane question, because if you were in certain neighborhoods in St. Louis in 1948, the answer is probably yes, because these things are so common that you may actually been on constructive notice that you were in a segregated neighborhood. And that if you were a black family walking around looking to buy a house, you're like, huh, wow, everyone's white. Huh. The same way, if you walk around a house and it's all one-family homes, you can't build an apartment building. So crazy, but you could actually have a constructive notice argument. One other point, and I'll give you a hint. Think of the Neponset case and how it concerned equitable servitudes. What was the tricky part of that case? You said it, yeah. Touch and concern. Ever remember with the equitable servitudes, a good little review, through the 3 factors, right? The most difficult one was whether the restriction touches and concerns the land. So in that case, the restriction was that you had to pay a fee for every square foot that you have, right? What's the burden on the land here? It's not you have to pay something. It's not that you have to allow someone to build a factory, you don't build a one-family home. It's who you sell it to. Does who you sell it to touch and concern the land, right? Does it matter who's living on the land, or what matters how it's being used? So traditionally, the covenants were based on how land was being used, not who's on it. So this is also a bastardization, if I can use the phrase, of equitable servitude law, because usually servitude has nothing to do with who you sell it to. We believe in free alienation. You can sell the property to whomever you wish, right? So at least 3 or 4 different ways these covenants were void under the common law of covenants, okay? Not that people care about common law, I do. But traditional property rules, which respected alienation, would not have permitted this. So there actually were changes in property law, totally apart from the Constitution, that enabled this case to work the way it has. Okay? All right. So any questions on the actual property aspect of the case? No?
No touching concern.
Unfortunately, the Supreme Court did not get into that. There was actually a case about 2 or 3 years ago, argued Supreme Court, that involved future interests, and I was all happy, right? Because I'm like the only common law person who knows this stuff, right? So Justice Breyer made some comments like, "Well, you know, I don't really remember property from law school," and it's true. Most of the justices probably haven't thought about covenants in years. So they were not going to resolve this under the narrow grounds of touch and concern, right? The Supreme Court case on segregation of communities, they're not going to resolve under covenant doctrine. They had to give, something a little more meaty, which is where the 14th Amendment comes in. You can imagine how pissed off people have been. It's like, yep, sorry, covenant does not touch and concern the land is void. That would have been a pretty funny holding, but also it would have only affected one case. And the Supreme Court tries to affect everything, and that would not be a holding consistent with the usual approach. Okay. Any other questions on that before we move on to the actual facts of this case? All right, so actually this is the Shelley house. I had a friend who was living in St. Louis who actually visited the house and took some pictures for me. It's still there, and you can kind of see it right there. There's a car blocking. There's a little plaque. You see that? And if I can zoom in on it. Oh God, it's so small. But this is the Shelley house, Shelley versus Kraemer. There's like a plaque commemorating it. The actual facts of the case are actually salient. So where did I finish up last time? Ryan, okay, yes, sir. Ryan, what were the facts here in the Missouri the Missouri case?
As we were discussing, there was a covenant that restricted what races could buy into the neighborhood.
Okay, so how many of the people on the block agreed to?
30 out of 39.
Okay, so let me pause here for a second. I'll come back to Ryan in a second. There was not unanimous consent, right? You want to talk about horizontal privity? Imagine trying to bind someone when not everyone on the block agreed. This was a serious, serious disregard for property law. right? Even without notice, and you don't even bind all 39 properties. And this does not come from a common subdevelopment. So unless there's some sort of constructive notice that you notice everyone's white, it'd be very tough for the black family here to even be aware of this issue. All right, Ryan, go on the facts.
So they have this covenant, and the plaintiff here, Shelley, tried to buy into the neighborhood. And I guess after they had already bought, when they were in the process of moving in, one of the other homeowners, Kraemer, sued for essentially an injunction saying, hey, this covenant forbids you from moving in.
Good. All right. So imagine what happens here, right? We have this restrictive covenant. It limits it to the Caucasian race, but not, quote, Negro or Mongolian race. Mongolian is a pejorative for Asians. Racism was not limited against blacks. This was actually a couple years after Japanese internment. Things were pretty rough in terms of the legal protections. So Shelley bought this land from Fitzgerald. Fitzgerald had no problem selling it to this family. He didn't care one way or the other. When the house was finally acquired, a lawsuit was brought by the neighbors. Now imagine this, right? These neighbors cared enough about this covenant, they actually paid their own legal fees and went to court to defend the covenant, right? All right, so this went to court. Let's see, which one was going? Yeah, you're up. Thanks. Okay, so Tyler, how did the lower court handle this? What did the trial court do here? It's actually interesting. Trial court's ruling here was actually pretty crafty.
For some reason, I want to say they upheld it. They sided with the neighbors.
No. What did the trial court do? Do you have it, Eric? It's mentioned. I mean, there's one sentence. Anybody?
The petitioners had no actual knowledge.
Yeah. So the trial court said like this: the covenant was never effected because not all the signatures were obtained. This is a legitimate trial judge who knows property law and says, okay, I can resolve this case in a very good property way. They didn't get everyone to sign it. There was no privity, right? Even under a very, modern approach, the burden could not run. But the Missouri Supreme Court reversed and held that the agreement was effective. All right, we'll go back to Eric. Eric, you notice there was this stuff about a Michigan case. What's this business about the Michigan case? You notice that? Or was that not in your book? Did they edit that out? Was the Michigan stuff in your case or they edited it out? I never remember. Okay, I apologize. So, yeah, so I read the full opinions, not the edited version, so I always forget what you have. There was what's called a companion case. You know what a companion case is?
It's cases where the facts, the issues of law are very similar.
Between?
If they decide on one, it'll be the same as the other, so they'll try them together or hear them together.
Yeah, exactly right. So often the Supreme Court will take several cases that present the exact same issue. The most famous is Brown v. Board. There were appeals from, Kansas, District of Columbia, Delaware, one other state I can't remember, right? Every state had the same issue, that's segregated schools. So in this case, it was a case from Missouri, and there was a case from Michigan called McGee versus Sipes. And again, there was a covenant that limited to the Caucasian race. It was the exact same facts. Okay. Interestingly, in that case, the covenant became effective when 80% of the people on the block signed off on it. Okay. All right. Okay. So we go to the Supreme Court. Now, as I mentioned before, right, the big question in this case is whether there is state action. Okay. If indeed there is state action, and it's the state that is responsible for this act of discrimination on the basis of race, the action is unlawful and unconstitutional. Okay? Josh, if I sell you a piece of land between the two of us, is a state involved with that at all?
No.
Okay. If I sell you a piece of land with a covenant on it, right? And then, you accept the covenant and you give me money for that, is there state action there?
No.
Okay, I'm going to give you one other example. I sell you Blackacre with a covenant on it, and then you go record that deed. Is there any state action there?
Still thinking out.
Okay. I sell you Blackacre with a covenant, you go and record it. You violate the covenant, you build a factory. I sue you. Is there state action there?
Not when you sue me, but it depends on what ends up happening after that.
I sue you and a judge rules against you. Judge says pay you $100.
That's when the state comes in.
Okay. This is fuzzy, and I'm glad Josh went through that the way he did, right? Josh sues Josh, I suppose. The definition of state action is not abundantly clear, and I think the court's opinion implicitly recognizes that. Generally speaking, if two people engage in a private transaction, the state isn't involved. But if there's a dispute and the parties need the courts to get involved to resolve that dispute, that, the Supreme Court says, becomes state action. Okay. The difficulty with this holding, though, Jack, is it possible to have a property system of any sort where the courts are never involved? Think about this class that you've taken. How many of the cases that we've studied wound up in court? Yeah, right? Every single one, right? Every case that I study with you guys is because someone screwed up somewhere and they went to court. The difficulty, right, with this decision where they interpret state action so broadly is that effectively every single property transaction which involves recording, and you said no to that. I don't know if that's so clear, right? If you bring a racially restrictive covenant to a county courthouse and you record that, I don't know that's so clear there's no state action. You have a state actor making that an official record, and people can then rely on that record in subsequent transactions. You're putting people on notice of a fact. So the tricky part about this holding, though, is that effectively whenever you involve a court, or I even say the county clerk, who records stuff, you're effectively making it state action. Jackson, what is not then state action? What's the only transaction, or what's the only way we can do business that would avoid the arm of the state? Think of the exchange I just had with Josh a minute ago. What's the only thing that the state has no business with? Private contract, right? Contract from A to B. I'm selling you Blackacre with a covenant on it, right? There's no requirement that you record. If you want to bind other parties, you have to record it, right? But if I just sell you Blackacre and we sign a contract, there's no state action. But Jackson, what happens if someone breaches that contract? What's the first thing that happens? They go to court. And once you bring a judge into the picture, is there state action? So this decision, I think you have to read as a product of its times. Okay, what do I mean by that? This was 1948. Congress would not pass a Civil Rights Act. I'm sorry, Congress would not pass the Fair Housing Act, which prohibited discrimination in housing for another 2 decades. Okay? This was still, what, 4 or 5 years before Brown v. Board. This was the Supreme Court, and I'm sure you studied this, slowly, gradually pivoting, slowly pivoting on the question of race, and not overturning Plessy, not overturning the civil rights case, but trying to recalibrate and find a way of narrowly providing some sort of protection against race discrimination without opening up the entire Brown v. Board of Education can of worms. Brown was still 4 or 5 years away at this point. So, yes, the court read state action in a very broad fashion. There's no dispute about that. It doesn't really apply many places elsewhere, because if you take this logic seriously, virtually everything that you do that could wind up in court becomes state action, and then there is no more private conduct. It's impossible to have a property transaction without involving the state somewhere. Okay? Okay. Any questions on this case? Effectively, the court holds when you involve the arm of the state to enforce a racial restrictive covenant, that is state action. And because of state action, there cannot be discrimination on the basis of race. Yes, sir.
The trial court said that the government wanted dollars because we didn't know. But when did the Supreme Court reverse? I'm understanding the Supreme Court saying, "Oh, you got state dollars."
The Supreme Court reversed the decision of the Supreme Court of Missouri. And the Supreme Court of Missouri held that these covenants were constitutional. And Jeffrey, to your specific question, the Supreme Court does whatever they want, right? When they reverse, they don't have to mention anything with reversing the lower court. They don't say anything about that. They can effectively rule how they wish. So they didn't touch the what I would like property argument about a lack of notice, and that doesn't touch and concern the land. But that was not their concern at all. Yes, Josh.
Didn't they kind of say that the covenant itself wasn't unconstitutional, but enforcing it?
Yeah. Okay, and that's an important point, right? If Josh and I make a restrictive covenant, that's, race restrictive covenant, between him and I, right? That's fine. But the second we seek to enforce it in court, which is what happened here, right? Shelley bought the house from Fitzgerald Fitzpatrick, right? That was fine. But what happened was a neighbor stepped in, went to court, and asked the court to enforce that discriminatory covenant. That's where the problem arose.
I think it's kind of silly. What's the point of having the covenant in the first place then if you can't enforce it? I mean, not that the covenant should have been constitutionalized. But,
Well, no. But I think your question is fair, right? If every covenant is written to be enforced in court in the event of a breach, then having a private covenant is worthless. Everyone see that point? The reason why we write covenants is because I don't trust Josh, right? If I trusted him, I'd say, Josh, you know what? I don't want you to ever build a factory. We shake hands on it. If I actually trusted him, I wouldn't need to write it down. The reason why I write it down is because if he breaks it, I can haul his butt into court, right? That's why we have property law. That's why we have contracts. So we don't trust people. Why should I trust people, right? People are deceitful. They're not honest. They change their minds once or twice, right? So I think that this case effectively makes all property law a constitutional issue if we take it seriously. Now, as a practical matter, do you see people suing under the 14th Amendment for restrictive covenants anymore? No. This is mentioned in the notes after your case. The Fair Housing Act was passed in 1968, really 2 decades from the date of this decision. And this law made covenants, racially restrictive covenants, illegal. It made certain forms of housing discrimination illegal, not all. It's actually very particular of how many rooms in a building. So, for example, if a homeowner has a basement they want to rent out, are they bound by the Fair Housing Act? No, they can say, I don't want to let the room to you because you're black, and there's no legal remedy against that. I think it's like 4 or 6 apartments, then you're kind of a landlord, and then you're bound by it. But the law has different protections for different sizes of landlords. In case anyone's curious, what is the constitutional basis of the Fair Housing Act? Commerce Clause. And the court held that the sale of property it affects interstate commerce, even though it's purely domestic and a piece of property cannot possibly leave state lines. Even 1968, the court upheld that as a regulation of interstate commerce. Okay. All right. Any questions? Yeah. By the way, it's funny. Whenever I teach property 2, I always get these comments at the end of the year saying, "Blackman's teaching us constitutional law. What, he's in the wrong class." Well, it's a significant aspect of property law in the 20th century was defined by the Supreme Court, and this is actually the first example. We'll start a unit in a couple weeks called takings, which is when the property is when regulations are imposed by the government. Does that amount to actually a taking of your property? Do they have to pay you for it? Right? Those are all Supreme Court cases. They're all constitutional law-ish. Some of you may study them in common law, but they are very properly related, and they are in the school-approved curriculum for this class. So I assure you, this is not for my own indulgence, but this is something you actually need to know. And if you're ever actually doing land use, much of what you'll do are takings. So this is actually quite relevant. So I'll hopefully preempt the comments. I think he teaches common law, and I get it every year. All right. Anything else on Shelley v. Kraemer? No? All right. So the next topic
that I want to discuss has to do with how do covenants go away? You know, I said perhaps a little glibly that if there's horizontal privity, a covenant will go on indefinitely. It'll go on forever and ever and ever. That's not entirely true. There are ways of ending a covenant, and there are also ways of courts tweaking, modifying covenants. And if you ever do some sort of land use litigation and you find that there's a valid restrictive covenant on your property, these will become your best friend. Because you're going to say, wait a minute, this covenant is like 100 years old. Things have changed. Oh, man, that's way, yeah, there's privity, but we got to go to this covenant. So this is actually a somewhat salient way to evade old covenants that perhaps don't make sense. Now, the book lists, the book lists 9 different ways. It's almost like a top 10 list, right? 9 different ways of terminating. Oh, I skipped you. Oh, you're smiling. See, that was your tell. Brendan, you told, you smiled. You're like, ha ha. See, you showboated, right? You're like the guy who you did the flip at the 1 yard line and fumbled. Remember that one? What was that? Yeah, that's it. He fumbled the 1 yard line, right? Anyway, yeah. So you're close, but not quite. So I want to walk me through some of the ways, and I'll move on to Will in due time, of how a covenant can be terminated. Just list it and just explain one at a time.
The merger.
Okay, what's merger?
When the Bennett claim land and the Virgin land end up being owned by the same person.
Yeah, this is the easiest way. So, right, if I own Blackacre, has a covenant on it, and then he owns Whiteacre, if he buys Blackacre from me, he now owns both pieces of land, both the dominant and the servient estate. If you own both the dominant and servient estate, poof, the covenant goes up in smoke. It's gone. That's an easy one. All right, well, let's see. What's the next one?
Full release.
Okay, what's release mean? This is not just a property, but you should know what a release is in all aspects of law.
It's a written or recorded statement saying covenant is no longer there.
Exactly, right? You'll see this in every single contract you ever read, a release statement, right? That's saying, I agree, yes, there's a covenant on Blackacre. Will, I am releasing you from the effects of that covenant. It's got to be in writing. It's got to satisfy the statute of frauds, right? Sorry, statute of fraud. And that is the manner, right, in which you can get away from it. Okay? Spencer, what's acquiescence?
Acquiescence is where the defendant goes to enforce the covenant against maybe one person or a majority of people, but I guess the majority of people want that against the defendant and tries to enforce it.
Yeah, acquiescence and the next one, abandonment, are actually kind of similar, right? If you stop enforcing a covenant against some people or all people, courts assume that you've given up on it. In other words, if you only enforce it against some people and not others, that means you're not really serious about it. So both acquiescence and abandonment are equitable doctrines, right? These doctrines effectively say, make sure you enforce your remedies, because if you don't, we may not enforce it for you. And also this raises the specter of your singling out certain groups and giving them special treatment. Okay, what's Jeffrey? What's Laches? My favorite, right? Yeah. Do you say Laches in contracts? Not really. Jeffrey, do you remember what that is? Like, how does that work? Anyone remember? Yeah. Yeah. So, by the way, I forgot. The federal event's tomorrow, not yesterday. So you can still come tomorrow at Thursday. I saw that was my reminder. This actually worked. Yeah. Laches basically means if you waited too long to enforce your claim, the courts won't enforce it. There is no statute of limitations in a covenant, right? We have statute of limitations to say you have to bring your claim within X number of years. If someone violates a covenant, there's not really a statute of limitations. Right? There aren't. Laches says, well, if someone was trespassing for 5 years and did nothing about it, well, maybe it's not that big of a deal. The others, let's see, unclean hands. In other words, if you yourself have violated a covenant, you can't sue someone else for violating it. And our favorite, estoppel. Estoppel is a general claim of fairness. This is the last best hope for judges to award equitable relief. If everything else goes out the window, judges say estoppel, this is unfair, and I will estop it. Estop is actually a verb. You can stop someone from raising a claim. It's a very common phrase, right? So the way it's used is like this. Say if in case A, the government made a certain position. They took an argument. And in case B, they take a different position, right? They're actually stopped from raising that because they've actually stated their position on an issue. And they generally can't change it at whim. The final one is the subject of our last two cases, what are called changed circumstances, right? Nali, what does this mean, changed circumstances? What's the meaning of this doctrine?
I think changes of circumstances is because the conditions outside the subdivision changes and then make the purpose of the servitude of the subdivision changes.
Yeah, exactly right. So what you said is right. When a covenant was reached in whatever year, there were certain conditions that made sense. So for example, if you have an area that says only residential houses in this area, right? Everything's limited. What if this entire, metropolis grows up around it and you need to build a hospital or you need to build a shopping mall or you need to build something else? Can the courts step in and say, okay, circumstances have changed, therefore we're going to enforce it against you? And remember, the second you say the circumstances have changed, you're effectively deleting the value of that covenant. When you bought a piece of property with a covenant saying residential only, that added to the price because you don't have to worry about cars and stuff. This is the same way with the implied easements by necessity, right? When you add an easement that someone can cross your land, you are diminishing the value of that property. You are making the property worth less. Okay, any questions on that? All right, Alejandro, you're up here. What were the facts in the Western land versus Truskolaski from Nevada? What were the facts there?
Well, the residents wanted to stop a shopping center from being built, and then the appellant who wanted to build the shopping center said that the area had changed, a lot of traffic was coming through, and it'd be more suitable to build a shopping center turned into a commercial area rather than residential.
Very good. Okay, so you had this area, right? There's a subdivision. If you notice, there are always subdivisions in every question, right? And the reason why your book puts subdivisions is because it's horizontal privity, right? When you divide a piece of land and you sell it to people with a covenant on it, there's automatic horizontal privity, and there's not going to be a question of whether the burdens will run. That's why your cases always involve subdivisions. Otherwise, it's hard to get everyone on a block to agree to have, only residential. So you had this a subdivision, 40 acres, and it was restricted to single-family dwellings. And in 1941, it was mostly used for residential and agricultural purposes. This is outside of Reno, Nevada. But as times changed, more people came to this area. Industry built up. People started living there. And someone wanted to build a shopping mall, right? So an action was brought to stop them from building the shopping mall, okay? And Greg, what happens? How does the court understand whether the covenant to enforce the residential restriction should remain?
They say that they can't build a shopping mall there because the residential area is still technically.
Yeah. Yeah, Greg, does it matter that the characteristics of the neighborhood have changed significantly over the last, 20 or 30 years?
No.
Yeah, and I think that's the key insight, right? Even if the community as a whole has changed significantly, the subdivision itself has not. It still remains a viable residential area. Now, Chase, what's the rub there? What's the reason why the subdivision hasn't changed? Why hasn't the characteristics of the subdivision changed? Think about it. What's prevented the subdivision from actually building other stuff? The covenant. So everyone see kind of the circular reason here, right? The subdivision hasn't changed, therefore we should keep it the way it is.
But the reason why the subdivision hasn't changed is because of the covenant they're suing over, right? Chase, how can a neighborhood under a subdivision ever change? How can the characteristic of a specific subdivision ever change if it's under a covenant?
I suppose it can.
Bingo, it can, right? And this is the significance, right, of the subdivision covenant deal. Once you make the initial decision to leave it as residential, it will remain residential unless they actually sell it and everyone basically moves out. But until that happens, you can't build a shopping mall because of the covenant. And if you do, the homeowner association or someone will step in to sue. So it's almost like a catch-22, right? You want to change the characteristics of the neighborhood, but you can't because you can't change the characteristics of the neighborhood. So once you measure it in terms of just a subdivision and not the community, it works. But I mean, so Will, does this neighborhood still work though as a residential area? Can you still benefit from it being residential?
Yes.
Can the children be safe?
I think apparently so along one of the main streets, and it's still not.
Yeah, I mean, this is a common theme. If everyone remembers from The Simpsons, Helen Lovejoy, which is the Reverend's wife, she always says, well, when someone please think of the children, right? There's always concerns of children running into cars. It's like the biggest fear of property scholars and courts, that these poor kids will be trampled by a stampede of Buicks or something, right? So the court holds here that it's not sufficient. The circumstances not changed, and they will not allow for the construction of this mall. Now, Omar, what about the fact that the city considered changing the zoning to rezone this area to allow commercial development? Does that matter? Why not? Why does it not matter?
Not persuasive, the zoning ordinance cannot override private.
Yeah, okay, and that's the key insight, right? So Omar, let me ask you this question, right?
What happens if the city zones an area as commercial, right? But a private property has a covenant saying residential only. Can you build commercial there? No, that's right. And pay attention, we'll do zoning later, but this is a little preview. When there's a conflict between a zoning law and a covenant, the more restrictive one controls. When there's a conflict between a zoning law and a covenant, the more strict one controls. So if the city says, yeah, you can build, commercial here, and the covenant says, no, you can only build residential, the more restrictive residential covenant trumps. Any questions on that one? Yeah.
Have courts ever taken the opposite approach that it's the benefit of the society to place a hospital somewhere?
Well, I mean, that's the next case, right?
Yeah.
So I'll get there in a minute. I promise. I have nowhere else to go. Yeah.
You brought timing issues in terms of competing between its own ordinance and a covenant. But even if the covenant was established first, then I mean,
It wouldn't matter. Even if the covenant came later, even if the covenant came after the zoning law, whichever is more strict controls. So if the city was zoned in 1950 as commercial, right? And then in 1975, you put a covenant for residential, it's residential limited. Whatever is stricter, not whatever is later in time. Other questions? Yeah. Oh, whichever places more restrictions, right? So we'll do zoning later, but think of it like a pyramid, right? At the base, you have commercial. In an area zoned for commercial, you can build whatever you want. You can build a commercial house, you can build commercial, you can build a house, whatever you want. But if it's zoned for one family residence, that's at the top of the pyramid, it's very strict. And all you can build there is one family residence. You cannot build commercial stuff in there. So when I say more strict, that basically means family residential areas. We don't have this in Houston, but if an area is zoned for family residential, that's all you can build there, one family. You can't build an apartment complex. You can't build a shopping mall. You can't build a gas station. One of the things about Houston we'll study is that we don't have that. So you can have a one-family house across the street from a shopping mall next to a gas station, and that's our town. We'll do Houston zoning in a couple weeks. I promise. I find it interesting. Any other questions in that case? All right, Evan. Rick v. West, what are the facts there?
This guy, or the plaintiffs wanted to build a hospital on a subdivision of 62 acres, but there's a covenant that said it was only being used for single family housing, and so they took Catherine West, the defendant, to court to try to build their hospital.
Right, yeah. And what happened?
She won because there was no substantial change to the neighborhood, and the covenant was still effective. She had a right to rely on that covenant.
Yeah. So, I mean, this is your question, Chase, right? Effectively, so long as a valid covenant's in effect, courts are not going to rewrite them. When Miss West bought this property, right, Jimena, when she bought this property, what was the impact on her purchase price of this residential only covenant? What do you think? Yeah. If you want to buy property zoned commercial, it's going to be pretty cheap. If you want to buy property zoned residential, it's going to be more expensive. Why? Because you're not going to have all the side effects of commerce. You're not going to have the cars, the traffic, the crime, whatever else. You have a nice, secluded residential neighborhood. So the court basically says, we're not balancing equities, right? This is not like with a nuisance where you say, which is, the greater nuisance, and, we can make her pay damages. With covenants like this, it's pretty strict. And the courts at common law did not allow, unless there's crazy circumstances, the modification of a covenant. Okay? Even if for something of such a great societal value as building a hospital, right? This is not building a shopping mall. A hospital will benefit everyone in the community to have a nearby hospital. But they didn't let this one happen. Questions on this? The book mentions briefly the third restatement of property, which I mentioned only briefly, where they make it easier to modify servitudes after the fact. This is not the law in Texas for sure, but virtually no state has adopted this. States still stick to the common law rule where these covenants are not modified unless there's some really crazy situation. Okay. Any questions on these cases? No? All right. Have a wonderful day. I'll see you all on Monday. Yes.
Can I rely on this for this class?
I don't know that book. I've never seen it before. I have no idea.
Okay.
I mean, you can use whatever you want, but I've never used it.
I just didn't know if it. Okay, you don't. I understand. This for purposes of the exam, should we rely on restatement second?
Well, no. Well, I'll tell you. Like I'll tell you if I want basically common law or modern approach.
But if you say modern approach,
it's third.
Modern approach third. So, what? Under any circumstances, would first or second?
The modern approach usually second or third.
Modern approach second or third.
Yeah, and I'll just tell you restatement. I'll say the modern approach restatement third. You'll know what I'm talking about.
Okay.